One of the purposes of this site, in fact, the primary purpose of this site is to educate the public about what actually happens. Most people in the public really don't have much interaction with the court system unless they're going in to pay taxes, meeting an attorney there, having a minor fender bender, maybe a traffic incident, possibly going in to look at a land issue or see something recorded on a deed or something. But most people are not going for some kind of major litigation, certainly not criminal litigation, although by some estimates it's 1 in 3 who do, but that still leaves the overwhelming majority really not connected to what's going on in the so-called justice system. It's much easier, despite these many legal advocates and pundits I listen to sometimes on TV, um, who are former prosecutors, many of them. I really take issue with them on the so-called justice system. It's a legal system. That's what it is. It's a legal system. Remember, I remember years ago reading in Columbia Journalism Review that it was against the law to push a cart down the middle of Main Street in St. Louis, Missouri, an ox cart. And the idea in this article was the purpose of it was to show that there are a lot of silly laws on the books that no longer apply. Well, remember, a black person used to be what, 2/5 of a person, and that no longer applies. So I'm not swayed when somebody says, oh, that's against the law, because the law is designed to change with the times. And so it must when we're dealing with things like stings and the sex offense registry, as I call it, and others. So here we have a case I want to take up today, which is the case of evidence. Most people probably have, a pretty um, standard definition of this. They feel it's something ubiquitous. You hear evidence. Also, people argue and they say, well, the evidence shows political evidence, legal evidence, social evidence. Whatever case you want to argue in your private personal life, you talk about evidence. Well, what we find out in the legal profession is evidence is not as they have taught us by the prosecution, the judges, and the way it's supposed to be. No, what evidence is actually whatever the judge thinks it is. And if you think I'm crazy, go ask a prosecuting attorney who gets the final word on whether evidence gets entered into the record, in other words, accepted by the court as something it will look at, whether you tick off the judge and the judge decides, oh, I'll let that in, I just won't pay as much attention to it, or I won't weigh it as much, or. So if you think that anything in the legal profession, anything in the legal system is pure, well, you're just naive, bluntly and totally honestly. You're naive. You don't know what you're talking about. Those of us who have seen the ugly underbelly of the legal establishment can tell you it doesn't work like that. Any defense attorneys who've seen their clients go to prison unjustly will tell you that. Even prosecutors will say that sometimes it's unfair and they understand they have most of the cards. And the evidence is one of the cards that they have. So, what we're finding more and more, particularly on sex offense cases, as we're fighting back, as we're demanding the evidence, all of it, in a timely fashion, is we're getting several stalling games and little games that they play. And before I get into the game, I'll just explain. I've been fighting this since before 2018. In 2011, I went to court being a nice guy and separating from my wife, who was abusive physically, mentally, emotionally. And my intention was to take care of my daughter, and I did all those things. But almost immediately, I was hit with an order claiming abuse. They waited till I was out of town. And then I had a deputy sheriff calling me, screaming at me over the phone. When I was on my way back from visiting relatives in Rhode Island, and then put his finger in my chest and in my face, telling me I can't abuse my wife and all this other nonsense I had not done. And listen to the court and court officers argue when it was convenient either I was never home, so I wasn't a good father and provider, even though anytime I was home after working my 5 jobs, I was taking care of them. And then conversely, alternately claiming that I was always home and all I did was beat people up, both of which were not accurate. And that's a nice way of putting it. Some of it was absolutely bullshit. But it put me in a position where all I wanted to do was get the court to enforce the simple terms of the law of our agreement, which is carried under Virginia law and every other state's law, that they are supposed to allow both good parents who've not been disenfranchised, and I never was, access to their children. My children love me. I wanted to see them. I was denied. Over and over again, the court made excuses. Now, it's clear that courts have made up of people. We call them the court, but it's really a judge. It's a human being with a black robe on who has prejudices and viewpoints, and they know that they are in charge. And unless they do something so egregious, so crazy that they won't be supported at the appellate level, they're likely to get away with it. In fact, there's a 99% chance they'll get away with it. And it makes sense, right? We all get away with little things in our jobs. Those of us who have jobs where nobody's looking over our shoulder, sure. But when the stakes are this high, following the law carefully and being equitable and fair under law is really, really important. And that's not what's happening in any of these cases. Not in the family court in Alexandria under the very corrupt chief judge, Lisa Bondorf Kemmler, who will be featured in my book and quoted. I spent considerable amount of time getting transcripts done so I could have her exact words in the exact dishonesty that she engaged in, as well as the lower judges that she directed to do certain things. It's astonishing. I can come out with a book hopefully soon, the next 2 years, and hopefully you will read it. It is mind numbing what they get away with. Now, applied toward sex offenses, well, they have all the cards. And the first thing they have is public perception. And that's powerful because not only are you fighting your psyche because you're being attacked from within, and you're going through everything you did. What did I do? Did I do this? Did I do what they said? Did I make a mistake here? And then you're being attacked by the public because they rush out a press release, which the media picks up directly from the police. Within 24 hours, they post it everywhere for as many as 3 to 5 days, tampering with effectively the potential jury pool and getting people turned against you. Okay. And now they say the playing field is level and we're going to look at the evidence, excuse me, and see what you did. Well, look, folks, you don't have to be a genius to figure out that you have the word sex and child and internet or secret communication, or however you want to put it, and what the police say. Oh, this is one of the worst we've ever seen, they'll say. And then the media parroting that to find that you've already effectively lost. So when you get in there and they start talking evidence, the state is required to turn the evidence over to you. But guess what they do? They don't. They wait until the day before trial. And I've seen this, I've heard this over and over and over again, the day before trial. And then they give it to you in one glop. Okay. And then what they'll do is you will ask for a continuance, which will irritate the judge, pushing it forward while you review this so-called evidence. Often you'll find it's incomplete, doesn't have everything. Then you have to fight with the prosecution that goes on internally for weeks. Then you may or may not get all of it. They will certify on the other side that to the defense that you got all of it. And then they'll proceed to put on their case in chief, their case against you, and they'll start bringing up things that you never saw. And you can't object to it because they certified and the judge approved that you have everything. And unless you have a judge that is really fair minded and is not looking at the clock and not paying attention to the docket with all these other cases ahead of them that they have to get through, and not remembering for just one little minute that they get a report card based on how well they can hammer, how badly they can give you all the time and more as a so-called sex offender, which they get kudos for. Are they really going to let that slide? Probably. There's too many other things that they need to get to. And your defense attorney is one person, and they dare not run the risk of pissing off the judge. So now you have all the, some of the evidence, and your evidentiary hearing was not able to um, exclude some of that evidence based on what? It sounds nefarious, right? Oh, you're trying to hide evidence. No, what we're trying to do is make a trial fair for the defendant. Because if they, it, on the prosecutor's side, gathered evidence that was unfairly obtained and against the Constitution, against the law, without warrants, or in my case, with an affidavit claiming that a real child said that I'd shown them pornography. Not even good enough to say, they didn't even say child pornography, just pornography. And then never brought it up again just so they could get that warrant. Either way is dishonest in the extreme. And of course, they get away with it. They get away with it entirely. You have to pick and choose your battles when you're before the judge there, and the judge may not be interested in it. I know many times I put on my case. Oh, by the way, evidence. Yeah, let me talk about one more piece of evidence before I get to this next part. What is evidence? It's written records, phone messages, text messages, witnesses, but also what you or your opponent says on the stand. And then the judge has to decide basically who is correct, who is more honest. And when the judge has a prejudice against a woman or a man, the victim, so to speak, or others, then that plays right against you. In my case, again, going back to family court, I saw this too. I brought in witnesses, including my own stepson, and they still put a protective order against me because she asked for it. And it's very easy to get a protective order. That's another thing people don't understand. Oh, somebody got a protective order against a person because they're an abuser. A woman who's listening to this can go to the court and say that I abused that person, and they can probably get a protective order. It's that easy. And if you don't believe me, again, ask a defense attorney. How easy is it to get a protective order? And they'll say, well, there's a hearing, but in the abundance of caution, because they don't want to see women show up dead and so forth at the hand, and you understand that entirely, they do a protective order. Of course, women also understand this, so they go and they get a protective order, knowing full well they can stick it to the guy. In my case, there was an added caveat. My ex-wife, who was a foreign national, had learned and talked to me about this when we were married, and I asked her not to do it, and she assured me she wouldn't. That if you are abused as a spouse, an abusive spouse, you can be fast tracked on that citizenship, or at least a resident alien uh, track, and it'll solve a lot of your problems. You get a green card and everything because you have to stand there, 2 feet from this terrible abuser. They don't bother to find out whether that's true or not. They just listen to what the other person says. And I never found out about it for years. Nobody ever asked me about it. They just determined it without ever having a hearing. Nice, huh? So when we're talking about evidence, we're talking about the judge really deciding what the judge, through filtered through his or her prejudices, think is important. And now you're going to have attorneys on here say, well, no, it's a little bit more to it. Judges are different, and they weigh evidence, and there are rules of evidence. And yeah, that's all true. That's all true. But in the end of the day, what really wins is the integrity of the person with a robe. And we're finding over and over again that person doesn't have all that much integrity. We're finding the prosecution lies. They are often aware that the police are lying. The police will make up stories. If they don't know, they'll say, I don't recall that. And if you try to pin them down, I don't recall. And police are very practiced. They work with attorneys, and they practice how to lie in front of courts and juries and judges. And they're very good at it. And juries and judges, or at least judges, know that. But again, they're trying to get through this caseload. They already have their own prejudices. And if it's a sex offense that has to do with sex, minor, online, solicitation charge, you're guilty before you start. So that's just the ugly side of evidence. And in a world where they're hiding more evidence, where the prosecution has all of the cards, and you have comparatively few of the cards, you understand that it's really stacked truly against you. Just like a card game, just like the casinos, it's stacked against you. And the sooner you realize that, the more you have to play very much a hardball game, because evidence is one of those things that the public thinks is cut and dry. I've heard it before. Well, they have to follow rules. They have rules. Well, again, talk to somebody who is shellacked by the court, and you'll see just what the court officers, which include the prosecution and their shills, the cops, get away with. This has been ICAC Unpacked for the 11th day of December 2024. Have a good evening.